Hi everyone, welcome back. The last few videos we've been going over, I've been trying to explain how each one of us is the Chief Justice and that we have the power, trying to instill this in each individual. We have to know who we are and that we have the power, that we're in control. And so this is a position that a lot of people aren't familiar with, but that's the number one thing that we have to know, that we are the ones with the power. And so once we establish that and we learn that, then we have to know what the words mean and the process is in order to execute that power. So now we are convinced that we have the power, so now we have to know what it is that we want to do with the power. So we're going to have to learn certain words and understandings of how those words work. And one of the first things that we want to talk about is what they call jurisdiction. That would be the court and its authority, because we're the court in certain instances and other people are the court in certain instances. So we first are going to go back and learn what a court is, and we covered that, the definition. So with these courts, there's two basic understandings of what jurisdiction is. There's the in personam jurisdiction, and there's the in rem jurisdiction. That's the subject matter. So the person has to have jurisdiction, and the subject of what we're talking about, there has to be jurisdiction over that. Now, to get the personal jurisdiction in a civil case, it's called a summons. In a criminal case, it's called a warrant. The subject matter jurisdiction is given by the complaint. So it has to state certain facts in order to give the court authority to hear the case. So the subject matter and the person. So if we start with the person, we have to have a warrant or we have to have a summons. That's what's given along with the complaint. So in a criminal case, the short form summons would be the ticket that you sign. They kind of put in this short form deal because that's the way it's done in corporations, and we can agree to that and just do the short form called a ticket, and you can pay your fine and be on your way. If you want to fight it, then legally you want to understand how this summons, short form notice to appear, is being issued by you and you're agreeing to it, and you're saying you'll show up and appear. And if you look at the dictionary definition of what appear means, you're going to find that they think appear means enter a plea. But in common law, and our understanding is appear means you're there. So we're going to start getting into these words and understandings of what they mean as soon as you're faced with the jurisdictional issue, which is when you're served. So the process is served. There's in rem jurisdiction, that's the subject matter. You can tell that by what the complaint says, and the jurisdiction by in person is by the warrant. So if there's no warrant, then you're there voluntarily. And so we have to understand how could we possibly be there voluntarily when we don't really want to be there, and we feel forced to be there by the cop issuing a ticket. So this is where the game starts. We know we have the power, we know we can move the court, so how are we going to set up a defense, and where's the warrant? And why don't they have a warrant? So the reason why they don't have a warrant, I'll tell you, is because they're presuming that we're driving. And if you don't understand the difference between driving and traveling, then that's where we're going to have to start to define these words so that we understand which jurisdiction we're in, whether we're in a civil jurisdiction or a criminal jurisdiction, and whether they've stated a cause of action, and whether they have personal authority over us. See, these are the questions we look at, and when we go to these words and define driving versus traveling, we find out that driving is a corporate privilege. And if you're driving under a corporate privilege, then there's no need for a warrant because it's been waived from the beginning. How did we waive it? Just by letting them go forward with the presumption that we're driving. So every presumption of law is rebuttable. So that's one of the first principles we have to understand. So we can rebut any presumption they make. Well, what presumptions are they making? Let me tell you, the presumptions they're making is that we are driving by privilege, and they regulate us completely. And that's the corporate idea. Now, the common law idea under the Constitution is that we have a right to travel freely unrestricted. So if we're traveling by right, they need a warrant to stop us and see our papers. If we're driving by privilege, we're already regulated, and they don't need a warrant to see our papers, and they fine us and move us forward in a corporate structure that everyone agrees to by participating. So this is the key to our understanding of that we're the king, that we're the power. Then we have to know how to work the power. And the jurisdictions are where the power is played. We make objections to their presumptions, and then we can begin to create issues, because that's what the court's going to hear. And we twist the issues around to be the issues that we want to hear, not the issues that they're trying to move on us. And this is the battle, but because we know that we can move the court, and that we can create defenses, and that we can make motions to get out of their jurisdiction, that gives us the confidence, along with the power that we know we have, to move forward in the process of challenging authority. This is what we're going to do, is question their authority, because they're acting on presumptions that are rebuttable, and we are learning how to meet those presumptions. Because we know we got the authority to do it, the power. Now we have to learn how, which is the procedures and the rules, in order to challenge it. Because once we can do that, then we can work on our presentation. Because if we know these facts, but we can't present them to them so they understand them, then they'll resort back to the presumption. That's the game they play. And they play it really, really hard when they know that you're getting close to this understanding. And they'll lie to you, and they'll tell you untruths and disinformation and misinformation, just so that they can proceed with their corporate structure to get their fine. They want to get a conviction. It doesn't matter what justice is and where it is for them. It's conviction, conviction, conviction. That's all they want. And when we know that, we can proceed a little better in some ways, because we know where they're going. And they're going to go that way because they're going that way because it's the only way they're going to go. They very, very, very rarely give up. They'll lie first, because they know that we can appeal. So they give us the appeal right to get out of all their stuff, so they can lie and tell us whatever they want to say, because we can appeal it. So sometimes the strategy might be to plead no contest and appeal it. It's something to think about when faced with their crap, because then we can begin to defend it in the upper court. And they didn't give a trial, because they're supposed to give us certain things and provide for them, but they're making it more and more that we have to demand these things. So we have to be really careful to know that everything that we don't object to, we're agreeing to. Okay, and so we have to go to the foundation of their case and look at how it's presented, look at the jurisdiction in subject matter, look at the jurisdiction in personam, and prepare our defenses and demur or motion to dismiss, and put it to them, and then just let them respond and give them the opportunity to give us their side, because in the beginning their side is just a presumption and they don't state it. We have to give them the opportunity to state it, and then we can attack it. So we'll talk more about that later. Thanks for being here. This is Zeke Lehman for PowerPolitics.com. Talk to you later.